the changes were inevitable and the changes were required also, because these laws were originally framed more than a century back by the Britishers, and we could not have continued with these old laws, like this indefinitely. But according to me, this has been a little hurried approach in framing these laws. Under Article 348 of the Constitution, every parliamentary act has to be in English. Now, these three enactments have a Hindi name. Now, I am from Bihar and I am from a Hindi state, so to say Hindi state, but having studied in a public school, to understand the exact meaning of the word which have been used for the name of the three acts is difficult for me. So, I can only appreciate how difficult it will be for people who are not from Hindi speaking states. So, this enactment to frame an enactment of this kind with a Hindi name, according to me, is constitutionally not permitted in our system. And this is a very fundamental flaw. To understand which one is the IPC, which one is the CRPC, which one is the Evidence Act, actually, your language of Hindi has to be really, really good to be able to appreciate the nuances of the three statutes. But if I am facing a person who is in the legal field and from the Hindi speaking belt is facing this problem, you can understand how the rest of the country will have a problem with this. Without police reforms, giving such drastic powers to the police, according to me, is can breed more, I would say, injustice in the system than do justice. But in the present scenario, where there is no police reform happening and no political party is ready to allow the police to function independently, these powers on especially liberty and free speech will definitely be or likely to be misused. According to me, before you put these kind of laws into place, you should immediately bring in a law to make police reforms a reality. And when I say police reforms a reality, means that the functioning of the police, the transfer, the promotion, all that should be taken away from the state government and given to somebody else. The moment it goes outside the government, one can expect the police to function independently and at least implement the law as written in the books. Police reforms not happening in the country today, and then to decide that even a peaceful demonstration can be terrorism, according to me, makes these laws a little draconian, because our system, I would say, or our society or our constitution has been framed with free speech as one of the cardinal rules or principles of our system or of our ethos, and there appears to be some way of the political party of the day or the party in power deciding what is free speech and what is not free speech, which according to me is quite dangerous. There are definitely reforms of a routine kind which are of course appreciable: crime against women, gender neutral IPC, child being referred only as child and not minor child and child separately, to consolidate the sections relating to the body in one place, relating to sexual harassment in one place, rather than having them spread out in the entire IPC. These are all welcome changes, but these changes are more cosmetic. I mean, they may definitely help in sort of rationalizing or streamlining the working of the criminal justice system in some way. 511 sections have been brought down to some 300 something sections. So Obviously, that has happened because there was a lot of sometimes repetition, or sometimes some section were you could read the same offence in two different sections. So all that has been rationalized. So that that I would say the working of making a consolidated law on crime has definitely been done, and that's more purely an academic exercise. Constitutional requirement of taking the society and the structure in which we are, and the fundamentals of liberty and free speech should be an integral part of criminal justice system. That is where there is according to me, not proper consultation, or not taking the views of people who could have given you suggestions on this.
Like the judges, the advocates.
The judges, advocates. Of course, there was, I mean, when the law was taken in and brought back, they took some time to discuss. But for instance, when the one of these laws on mediation was being discussed, I was then the president of the Supreme Court Bar. So the parliamentary committee called me as president of the bar and took my views. Now, this kind of a thing should have happened here also. The bar should have been consulted, the High Court bar should have been consulted, the criminal bars should have been consulted. And so there is a prosecution bar and there is a defense bar. There are some very good defense lawyers, there are some very good prosecution lawyers. So the defense lawyers also view should have been taken, because the defense lawyer will understand how a criminal law is misused, and the possibility of misuse should be minimized. There are definitely some salutary provisions to expedite justice delivery, and those are welcome. And those are definitely, there are a large number of things in the amendment which are meant to speed up the criminal justice system, which definitely are.